What's up, everybody, and welcome back to another Sarah Boone video. It's a lawyer you know video, but it feels like we are already on our daily recaps of Sarah Boone because something kind of major happens every single day. And there were more motions today. It wasn't very long, but some more gruesome facts came out, and we get a little taste of how the prosecutor is going to present this case to the jury. And we have our kind of first heated exchanges between the lawyers. Seems like they might be a little annoyed with each other, or it just might seem like they are in battle mode because the battle has begun. And you're seeing it with the motions. The defense attorneys, I believe, are still questioning the jurors right now. They hope to have a jury pick today and maybe closing arguments, opening statements by the end of the day today, but at the latest Friday. So this case is on and running. Off and running. Clearly off and running was the statement I was looking for there. The case is off and running. So we're going to jump in with the hearing today. And there was some discussion about what the judge ruled yesterday. What did the judge say yesterday? And people were asking me on my Twitter, like, why do they do that? Everybody was there. Why is the state being so snarky about this? Why do they need the written transcript? Well, it's interesting, right? And I say this all the time about, giving trial lawyers a little grace, but so much is going on when you got a trial, when you got motions going on, you got people coming in and out, you got multiple members of the team handling different parts of the case. So sometimes you take notes. You always should take notes, right? Granted, denied, but when it's granted in part, denied in part, sometimes there can be a little muddy where what the judge actually said, what's allowed, what's not allowed. And good lawyers, in an abundance of caution, don't want to violate any court orders. So they ask for clarification, they ask for it in writing, and they make sure they don't break any rules in opening statements or throughout the case. That's what I think was going on here. Yes, it was a little snappy with the court reporter. They ended up doing the audio, which, I mean, at this point, this day and age, everything's happening on YouTube. The links are easily available. You can listen to them on 2x speed, slow them down when you get to the part where the judge actually makes his ruling. And in 5 minutes, you could have everything you need to listen to right there. I think that's what they ended up doing. But there was a lot of discussion about that because you just want to make sure it's absolutely right. Even the judge, if you noticed, didn't say, oh yeah, I granted this, denied that, granted this, denied that, because everybody wants to make sure you remember it and you get it right. And that's incredibly important. So that's what happened at the beginning of this hearing. And then we heard a bunch of discussion and argument about Richardson hearing and discovery violation. Richardson hearing was there a discovery violation? Did the defense violate the rules of discovery? Did they hide anything? Was it late disclosed? It pretty much is late disclosed. And the balancing test has to do with, was it willful or negligent? Was it material or trivial? And does it prejudice the state? Those are the questions, because if it was negligent and it doesn't prejudice the state and it's something trivial, no big deal, it can come in. Obviously, if it's willful, that's a problem. If it's material and prejudicial, that's a problem. The judge, I think, might have the Richardson hearing at the end of the day today, may have already had it. I haven't seen what happens at the Richardson hearing. I don't think it's going to be much of anything. And we're going to see kind of how the defense is dealing with the state's objections to their exhibits. And so many times they kind of back down and say, okay, we're not going to use that. We're not going to call that, et cetera, et cetera. I did want to mention a couple of things. I got a very nice letter from a lady named Teresa that I want to say thank you for. Teresa, if you're watching. And Chris sent me some Halloween goodies. So I'll be breaking into that box with my kids later. All right. So let's get in. And the first thing is just kind of a 1-minute clip I wanted to show you guys about the state made the statement that the judge said he read the depo, he heard Sarah Boone at the hearing, and there was no overt act in the discussion with the mental health experts. I don't remember the judge actually making that ruling, but let's listen to kind of this really quick discussion about it, and we'll see what we think it means for the trial.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was, if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today.
Judge is like, I'm not going to say whether or not I said that. So they're going to go back and listen. I don't remember the judge specifically saying that. He did say, what's the overt act? She didn't say an overt act. It did sound like, as he was discussing and thinking about it in his head, that he doesn't think she expressed an overt act. But that was before the defense, as they say again today, was forced to show their hand and explain what they see the overt act as. I don't believe I heard the judge, after the defense said that, say that's not an overt act. I'm finding as a matter of law that that's not an overt act. I don't remember him saying that specifically. I think that's a decision he's going to have to make in the future. And you guys probably aren't going to like this. And let's go to the AKA, the cat lady. How is the defense saying the overt act by George justified Sarah's behavior? Is his hand coming out of the suitcase? That's not an overt act. So what happened in this trial? So here's my question, or here's my kind of answer to this. There's two questions here. Is that an overt act enough for the defense to make that argument to the jury? I happen to think, yes, it is. If I was on the jury and the overt act came out the way that it's come out so far, that he stuck his fingers out or tried to stick his hand out, and we'll hear what she did when the state does their little mini opening. If I was on the jury and that's the overt act to respond with deadly force, that is far short of the bar to respond with force like that, in my opinion. But I'm reserving my opinion on that until we actually hear the evidence come out and what the experts have to say. But I agree with you that as it sits right now, that definitely does not seem like justifiable force. Bodie, a Richardson hearing is to get the details about the discovery violation, to figure out whether it was, like I said, willful, was it material, was it prejudicial? And that's what the Richardson hearing is. They say, we just got it this day, Judge. We turned it over as soon as we got it. We're late on the case. It's not a very big deal. The state already knows about this, or we've already told them about this. This is the documents following up, things like that. So that's what the Richardson hearing is to determine whether or not there was a discovery violation and what type of violation it was. Dee Dee, did she have her hairstylist today? I don't know. Hey, Peter, I'll be OOT until Monday night, so I'm hoping to be at the trial starting Tuesday. I hope to meet you when the time is appropriate. Thank you, Dre. Dre, I'm not positive how to say that. Next week's going to be tough for me to get there. I think the following week is I'm going to be there because Whitney's going out of town Thursday and Friday. So I'm on daddy duty alone with my kids who have crazy schedules. So next week's going to be tough, but I'm hoping the following week I can pick a day. Who said Sarah Boone has to testify by narrative? Judge K. So I didn't hear that in the hearing. So I don't know if it happened when the cameras were off. Joel from STS said that on Twitter. I reacted that I was a little surprised at that, since the lawyers have already asked her questions and elicited information from her. That's very different than what she said before. It was under oath. So if they were worried about candor with the court, I would have liked to seen that discussion. If any of you have seen it on YouTube, send me the link. I'd love to look at it. So that was stated by people in the courtroom, but I didn't actually hear that come out in front of the cameras. Matthew, cannot believe Sarah Boone is going to trial. Her ongoing antics have been a part of my life for years now. It's the case that got me into true crime. Isn't that interesting, Matthew? I'd be interested in hearing from a lot of you what case it was that got you into true crime. Okay, so the defense still has not whittled down a lot of their exhibits. They still have hundreds and hundreds of pages. The state's asking them to whittle down. Last night, they turned over 382 jail records. The state said only 5% of them might even be relevant. But again, these are all subject to discovery violations, which means the judge can just strike them if he finds that the violation is willful or that it's material and prejudicial to the state. So we're still kind of waiting to hear what the judge cancels out on that or strikes. None of this feels like a huge deal. I think if anything, it's small parts to prove battered spouse syndrome. So we'll kind of see. And again, a lot of this, we don't know what's in the 382 pages. So it's hard to really comment on it fully. Then they get into a discussion about Brian Boone. And this is where the lawyers start to get a little hostile towards each other, take some pot shots at each other. And eventually the judge calls everybody up for sidebar before ultimately making his ruling. But let's take a look at this exchange. By the way, I see you guys all throwing the names: Menendez, Michael Ross, Gabby Petito, Chad Daybell, Depp, Casey Anthony, OJ. I see you guys throwing the cases in there that got you into true crime. Interesting to me. Very interesting always. And I don't know if I said this already. Hit that like button. We got the last video to 10,000 likes like so fast. Let's see if we can do it again. Make sure you subscribe, share it to anybody that's following the Sarah Boone trial.
Filed that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family
That was a previous ruling, but the overt act subject is placed into evidence.
law case file Boone v. Boone, case number 2017 DR 01.
Because I paused it there, it might be a little choppy, so I'm backing up. They're trying to get in the family law case file, Boone versus Boone, between Sarah Boone and Brian Boone. The defense is trying to get it in to show the hostility of Brian Boone, adverse witness, and to show his bias.
Family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, we anticipate is going to testify for the state, we testify for the defense, and he may be considered.
So the prior comment is how bad the audio is. Don't worry. I'll recap and repeat the stuff we can't hear so you can keep the context of what's going on.
Adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect for impeachment purposes the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement he originally had, and he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that force of their.
What does the
It's but a whisper, but here's what he said. When we call him, if we call him, he's going to be hostile. This will show why. He's also going to be biased. And we're going to show through orders and stuff that's happening in the family law case why he might want to come and testify against Sarah Boone, why he may say negative things about Sarah Boone. And they have the recordings where he does talk about some of the abuse going back and forth, that Sarah would flee to his house. So there are some good facts that the defense wants to get out of Brian Boone, but they're going to say, we're going to argue all those bad facts that he's blowing up and making her seem even worse is because A, he doesn't want to pay her alimony. B, he wanted to move the kid out of town and was able to move their child out of town. I don't mean to be crass when I say move the kid out of town. I mean, that's how the defense is going to couch it. He wanted to take the kid and stop paying the money. That's what they're going to say. And that's his bias against Sarah Boone. And that's why he's testifying negatively to Sarah Boone. Now, should you be able to put a court file in for that? Sometimes it's necessary, sometimes it's not. And if I was the judge, I would make him just ask the questions to Brian Boone first. And if Brian Boone says yes to him, there's no need for that court file. If he says no, you may have to refresh his recollection or impeach him with those documents. So it is possible that this becomes relevant, but that's what they're kind of discussing right now. And it gets a little snippy here between the lawyers.
What does the non-payment of alimony have to do with what's happening in a family case?
It's, to me, I get the judge's question, but it's very relevant to his bias. And frankly, he's trying to stop paying because she's in jail. So if she stays in jail, it literally saves him money. So I do think that that's a question the defense should be able to ask. Does that mean he's lying? No, but the defense should be able to ask it, and the judge or the jury should be able to weigh it in the credibility of his testimony.
But Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony. He's supposed to pay $1,000 a month for a number of years, and he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated. and they would probably want to seek legal redress about those issues.
So I think the state is conflating issues, and kind of what Bodie's saying here. What did Brian do wrong? I haven't heard anything. Nobody's saying he did anything wrong. Absolutely assert all your legal rights. And if that's how it works in family law and you can stop paying alimony, great, do it. That's your right. But the defense has the right to, same thing in civil cases, sue your perpetrator. Sue them for everything they have. If they damage you and they do stuff to you, like, we see going on in the Diddy case, for example, he's presumed innocent. But if he gets convicted and all the civil lawsuits come, go ahead, do it. But if you testify, they're allowed to ask you about that. And the jury's going to have to weigh, are they telling the truth or are they just saying things for money? It's the same kind of deal here with Brian Boone. Not saying he did anything wrong, but it is a fair question for the defense to be able to ask him. Nina said, a serious question. Do you remember Jose Baez bringing up the essay by Casey Anthony's dad in his opening statement, but brought no evidence of it during the trial? How was this allowed? So this type of stuff happens sometimes, and criminal defense attorneys, I've said it a million times, get away with way more than prosecutors, civil plaintiffs, lawyers, or civil defense attorneys. Because if they win, 99.99999% of the time, it's not appealable. It's over. Double jeopardy. So they can take some risks. They can toe the line. Prosecutors, that's why they have to be vigilant in holding their feet to the fire, making sure things are appropriate, making sure objections are made and instructions are made. And they should have been. The prosecutor, I don't remember that case. I didn't watch that case gavel to gavel. But in that situation, a prosecutor should be able to say, you hear they said that in opening statement, not a shred of evidence came out about that. They're trying to garner sympathy for this defendant that doesn't exist. So don't be tricked by the words that they're saying in opening statement when no evidence of that came up. You're only allowed to consider evidence that came out in this trial. You're allowed to make arguments like that if this situation comes up. Chris K said, your coverage of the Waukesha parade attack got me here. The snacks are for you and Sarah, LOL. Box number 2 should arrive today with Starburst, Skittles, etc. Oh no, I should have known there was some kind of irony in your gift. But yeah, so I said Waukesha. There's so many like names and cities and places that are in my head that my brain freezes when I see them, like Moscow, Idaho, and all those things that I've learned how to say thanks to a lot of you guys. All right, let's keep going.
It sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
See, I think, again, I keep repeating myself now, but I don't think that's the issue. The issue is just bias. It's not that it was an order. It's not that he did stop paying. It's that he wants to stop paying. And this is why he thinks he can stop paying. If he does something to keep her in jail, because if she gets out, he has to pay, right? Especially if she's not guilty, he should have to pay back alimony because she was wrongfully in jail. Not wrongfully meaning she should be able to sue them because there's probable cause and there's bail and everything set. But if she's not convicted of any crime, he should have to pay alimony for all that, right? I think we can all agree with that. Take Sarah Boone out of the equation, just Jane Doe.
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
So if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case. I haven't looked at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
Maybe that wasn't where they got snippy with each other. Sorry. I thought that's where it was. Maybe it's in a different part. But so he basically says, hold on, let's just chill with this for a second. Everybody come up here. And then they end up overruling the objection, meaning the defense can possibly get into this. I think, and I'm guessing because this happened at sidebar, it's you ask Brian Boone, if he admits it, fine, you got his bias out. If he doesn't, you can refresh his recollection with some of these court documents. Let me see here. Peter, do you think she has a chance that she doesn't get found guilty? I mean, I think there's always a chance. It seems like the odds are stacked against her, but she's presumed innocent at this point, and the defense, I mean, the state has to prove this case beyond a reasonable doubt. Okay, the next section we're going to get into is here's where it is, where they say you forced us to give an overt act. The state's hiding the ball, basically, and they kind of go back and forth here. This is the big chunk of argument we're going to listen to today.
Based on the court's going to overrule
This is post sidebar.
the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that.
And I wanted to play this part so you guys understood. There are so many things the defense put on their witness list that they were like, yeah, judge, we're not going to use it, so we take it off. That makes the judge's life easier. That makes the state's life easier. But you will also hear the defense not necessarily say, we're not going to use it, judge, but they do say we didn't get it because of the time constraints. And the judge says, I'm going to strike it because you didn't get it. And on the record, Owens is saying, we never got it, judge, so we're not going to be able to use it. So those are the types of things that are setting up an appellate argument, all based on the lack of a continuance that the defense said they needed, said they wanted, and the judge did not give them. So that's something just to keep in the back of your mind. Every time you hear, didn't get it, didn't have enough time, we've only been on this case for 45 days or however long it's been, all of that is setting up the record for, we needed a continuance and you said no, and you're forcing our hand here to trial. And that's something that, could potentially become an appellate issue in the future.
That objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. And court takes no action based on counsel's representation. Moving to 32, iPhone photo.
I need,
Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to,
There was a lot of this, even more than I'm showing you, that they're like, we're not going to use it. And this is stuff they put on the exhibit list.
48, another iPhone photo file name, 505 period JPG _ embedded _ 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and
Which
60.
again is an indication to me they weren't fully prepared. They put everything on the list. They threw the kitchen sink, and they're going to whittle it down kind of as we go. And they were like, just in case we're going to do any of this here. But there could be another reason they have all these exhibits on the exhibit list. And we're going to mention that later when they talk about some of the witnesses that are on their witness list and why they may be there.
I understand your objection, State. Any response?
Any and all exhibits previously listed by the state?
So the state is like annoyed by that. Any and all witnesses and exhibits by the state. I would put that on every single one because it's a catch-all. And if they've got it listed, how could it be prejudicial if I call them, Judge? If they've got an exhibit listed and I want to use it, how are they going to object and say it's prejudicial? They listed it on their witness list. It's a catch-all. We're allowed to use it. There's nothing in the law that says we can't use it, number one. But this is, I think, where the spat, I keep telling you they're going to start going back and forth because I can't remember exactly when it happened. I will mention when the new gruesome details come out that I at least never heard before or didn't know about that happened that night. But this is, I think, I'm going to guess again, where they start going at each other a little bit. It's pronounced like Dr. Dre with an at the end. Okay, Drea. Okay. I had a friend named Drea. His name was Andrea. He was Greek and he went by Dre or Drea as well.
Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And
so he's going a different direction than what I said. What I said to me, I think, puts the judge in a difficult position because is he really not going to let me list all the state's witnesses and exhibits? Is he really going to do that? That'd be a very weird precedent to set. So I would have just thrown it at that. You don't have to get so detailed and argue your entire case in front of the judge. I feel like that's happened so many times in these motion hearings. This is not the trial, right? It's pre-trial. There are different rules. So he goes a different direction. He's like, well, Judge, because they haven't given us a statement of particulars because you didn't make us make them give us any more information, yet everybody keeps forcing us to give information. It's just not fair. That's why we have to list everything. It's like, that's not the best legal argument, in my opinion. It's not the best legal argument, although I don't disagree with him. It's just, this is a very normal thing that happens in basically every case.
practically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word over.
Judges like chill with the forcing. Nobody forced you to do anything. If legally you have to do something to clear a bar, then legally you have to do something to clear a bar. But I read that deposition and she did not say she was in imminent fear. So now the judge, again, they're discussing the facts and how the judge reads the deposition and what he thinks. This is not the same thing as making a legal ruling on whether or not there was an overt act. It's very different. The judge is just discussing what was in the deposition. And Owens makes a good point about why the deposition may have seemed or sounded the way that it did. And it's not the end all be all when it comes to discussions like this.
Overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday, in limine to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it.
Woo. He was trying to control her. He was cutting her off. He wouldn't let her explain her answers. And while it's a little bit of a shot at the state, it is what happens sometimes in deposition. It's like, you didn't get the information that's there because you didn't ask the right questions. I know information you don't know because you didn't ask the appropriate things in deposition. And there's nothing that forces me to make the expert do that. Now it can come back to bite you as the defense, because when somebody says, hey, you don't have this evidence, well, you could have had it if you asked the question. So it's a balancing act of whether you want to, keep things close to the vest or let it all out there so the judge lets you present your case the way you want to.
Going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that, but that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know.
This is just not the right argument, in my opinion, right? It's just not the right argument. I don't know why he did that. This is not the right legal argument. While I think they should be able to list this on the exhibit list, because I do every single time, this is just not the right argument. And he keeps trying to make the argument about the facts and the overt act and the statement of particulars. We all know what this case is about. We all know what the state's going to argue. Why is he acting like they don't know what they're going to argue? I don't understand. Even though I do think you should be able to list all the state's witnesses and exhibits on your exhibit list and witness list.
It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder.
Again, two different issues. You do know the facts that they're relying on in this case via the statement of particulars, but also the discovery, the exhibit list, the witnesses, what the witnesses are going to say, the depositions, you know. Number one. Number two, you reacting to opening statements. In no trial does the other side have to give their opening statement to you first so that you can prepare. You're always reacting to opening statements and closing arguments. You're always reacting to direct examination on cross, or on cross-examination, you're reacting on rebuttal. That's what lawyers do.
So in an abundance of caution, we've got to list everything that, but we don't know yet because we haven't heard. I would like to renew. They've renewed their motion on battered spouse. I would like to renew my motion.
He loves to be like, well, they got to do it, Judge, so we should get to renew our motion on the statement of particulars. Judge is going to be like, okay, denied again.
For a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir.
It's just, I don't like certain disingenuous arguments where it's like, we don't know what we're accused of. It's like, I mean, I get it, man, but you do in this case, especially. So now we get a little mini opening statement, just like we talked about in Delphi. This is not in front of the jury or the jury panel or the prospective jurors, just for the judge. Jay is going to, I think his last name is Jay, is going to say, here's what we got, Judge. Here's this case. Here's how this is very simply second degree. And at the end, the defense is going to be like, well, thank you. You should have done that earlier. And it's like, oh boy. It's like, I don't know. Did you really want that? It's like, be careful what you wish for sometimes. But here's where some of the gruesome new details come in that I was like, wow. I knew there was going to be information we don't know. That happens in every trial. But this one was a wow moment.
Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble.
So first off, that's even a little different of an angle than we've heard so far, is even if her fear was reasonable, even if she did start to say, oh no, now that I've poked the dog or poked the bear or whatever it is, because I've hit him and I've done this stuff to the suitcase, now that I have been the initial aggressor, I'm afraid he's going to come and do something. So even that wouldn't be enough for self-defense because she's the initial aggressor. So even an additional angle to what we've all been discussing here.
And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change.
Hey, I'm glad I'm not the only one. I think he was looking for can of worms. But he's like, if she changed her testimony, then again, we'll deal with that at that time. But if she has the same exact testimony, I'm going to go up, object, and not let her get into the past issues with George, maybe some violence, his character, because she has not gotten to the self-defense. She has not gotten to the battered spouse syndrome. So Leslie said, I'm confused. Is battered spouse being allowed? So yes, as of right now, as long as they produce the evidence necessary for it. If they finish all their evidence and testimony and they're going to call their expert and the judge finds you haven't presented enough with the overt act, that it wasn't an accident. If you haven't presented any self-defense evidence, then you're not going to be able to go into expert testimony, battered spouse syndrome, the character or violence of the victim. You're not going to be able to get into any of that. But as of right now, everybody's allowed to argue it. They're allowed to talk about it in opening. The state's allowed to respond to it and say, we think that that's what's coming out in the case in opening if they so choose. So as of right now, yes, it's in, but that doesn't mean it's staying in. Nina said, Peter, what's your best defense? It would be something centered around something he said or did in the suitcase, freaked out Sarah Boone. So she was like, I got to leave him in there. And then she passed out because she was drunk. She didn't, mean to hurt him. There was an accidental element to it, but she did intentionally leave him in there to protect herself because she was in fear of serious bodily harm or death. I don't think it's a great argument, but I think it's the best one I can come up with what I know. But there are more facts coming that, I didn't know until today. So I assume that's going to continue throughout the trial.
During her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence. and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that's...
So here we go. This is the state's case. This is his mini opening statement right here. So take a listen and see if you hear any facts that we haven't heard before.
This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah.
Unintelligible, drunken, slurred words might not be something he can say in front of the jury until after, I guess, she testifies that she was in fact drunk. What's interesting is I saw somebody in the chat say he should be slurring his words for emphasis right as he said that. So he is letting the judge know exactly how this sounds. I'm sure the judge has already seen and heard it, but this is good narration. There have been some things I like and didn't like about his presentation and his arguments. I thought this was effective.
Sarah. Sarah, I can't breathe, baby. That's what I feel like when you cheat on me. Sarah. F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth.
Now, I don't know if this was just the pattern of his verbiage or if I'm reading too much into this, but it sounded like he said, hit him with a bat, and he had blunt force trauma to both sides of his face and his mouth. We heard about some of that. Sarah Boone denied that in the interrogation. I think he's quoting or getting a lot of his details from the depositions from what Sarah told the mental health experts. But beating him with a bat, not just in his hand, both sides of his face and his mouth, if they prove that, she's cooked. If this is the evidence that comes out, this is so much more than just leaving somebody in a suitcase, which is horrible enough. But this shows a different kind of intent. And I think he's either already said it or is going to say that is a depraved mind and heart. I mean, that gives you the chills to think about what she's doing. Literally, somebody's in a suitcase, you're flipping it upside down, shaking it and beating it with a bat. I mean, that's got to be top 10 worst ways to die. Like, I mean, that is just, this was very effective as a mini opening statement. I'll just say that.
That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago.
His only rebuttal is like, shoot, that sucks for us, but that's a lot more detail. That's a statement of particulars. And so here's where we can't get confused, because we absolutely have rights. Criminal defense attorneys have the rights of their client, the criminal defendant, for a statement of particulars. That does not mean you have to hear the state's opening statement like he just said. He does not have to provide that to you in writing. That's not how the rules are. So he's, again, conflating issues here, but now he knows, right? No argument. He doesn't know what they're going to argue. That's the case in a nutshell.
She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Warner, 5 of us there. Dr. Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Warner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Warner. And jury.
Once again, not to harp on this too much, but he brought up the statement of particulars. What are we talking about now? We're kind of already past the fact that, yes, she's going to testify, and then the judge will make the decision and deal with whether or not we can go forward with the battered spouse defense. Like, that's already happened, but it's rehashing the same issue here.
While we're here, they are going to have to decide who to believe and what happened.
Agreed.
But that is a jury question that we're all going to have to wait for.
Correct. But it's not always a jury question, right? There are certain things the judge can step in and be like, no, there's not even, she did not testify to enough to even get to the battered spouse defense. And that's what they're talking about. I forgot, is the actual video still coming in? Yes, the defense did not even object to it. And there's not really a great objection to it. So I don't blame them for that. You should team up with Melanie Little. She is down. So, you know, there's like tons of people that are awesome on YouTube. I don't know Melanie Little at all. So I don't know. I know that she is a lawyer. I don't know, you know, what, if she's following this case or if it's another case you're asking about. The only time that I am able to have people on and really have conversations with people is on the podcast for like specific cases and stuff. So, and I have a list of awesome people I'm going to try to get to. I'll put her name on it and we'll see if there's an opportunity for us to get there for sure. You can't handle the truth, Mr. Owens. Yeah, that's something.
I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 states list?
I don't know.
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose them. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe.
He says, I may not call them, right? She wants me to put them on the list. She wants all these witnesses, which again, that's not very uncommon for defendants to say that, you know, that's what they want. Call this person, call that person. But at the end of the day, the trial strategy is up to the defense lawyer. And he's like, listen, I don't know if I'm going to call all of them. She wanted me to put them on the list, so I put them on the list. That's basically what he's saying, which gives you a little insight into what the relationship is like and how it is prepping this trial and trying to get these witnesses. He's like, I'm doing the best I can. Actually, so there's one more small clip I want to listen to. Afton said, did Owens try to exclude the cell phone evidence through trickery? The defense objects to all cell phone video evidence. No, I don't know, obviously, his intent, right? I can't assume his intent. But the way I look at it, it seemed more like he was not prepared to make the individual objections, but instead he just kind of objected to everything and was going to deal with it later. Number one. Number two, he wanted to preserve the right to object to it during trial, which is correct. You should still be able to object to that stuff during trial. If something doesn't come up, it's not authenticated, there's an issue, it's not relevant, whatever may happen, you have to have the ability to do that at trial. So that's, I think, what he was really trying to do is preserve his right to object. Peter, what happens if it turns out that one of the jurors had knowledge of the case and made comments against Sarah beforehand? Well, as long as they're open with the defense attorneys about that and the prosecution about that, then it's fine if they still let them on the jury. But if they lie about it or they say, never heard about it, have no opinions, have no statements, well, then it creates the issue that they lied under oath and they didn't reveal information that was pertinent and material to the case. That could be a major appellate issue, obviously.
My right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right,
Sorry, he was just saying that's trial strategy. They take a break and we're going to come back and just a couple more minutes here.
Before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health Records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
Right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her.
So the judge is like, state, defense can't call any of these witnesses they listed late unless you get a chance to depose them, and the defense has to pay for it, pay for the expedited transcript because it's their fault because it was late. The defense is like, well, judge, us too, they late disclosed certain things. And the state's like, whoa, whoa, whoa. We just substituted in witnesses because we didn't want to continue the trial, and there's another witness that could testify to somebody that was unavailable. It's like, well, it is kind of the same thing. It's a late disclosure, and I get you don't want to continue the case. You can continue the case. That's an alternative if you want to ask for that. Then it's up to the judge. But if you're going to give new witnesses, what's good for the goose is good for the gander.
Who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in.
All right. So then they go back to picking a jury. But it's always funny when it comes back on the prosecutor. They're like, whoa, wait a second. Something bad for us. And said the defense lawyers are somewhat rusty. The 911 call is not being used by the defense. Can the prosecutor? I don't know what's listed on each exhibit list, but yes, the prosecutor would be able to use the 911 call if they want to. Can the prosecutor use 911 calls? What I meant, she came across as cold and matter of fact. Yeah, I think they're going to have a lot of her statements in this trial. A lot of her statements. Manley said, do all attorney staff in Florida look like Charlie's Angels, or is this an enigma? LOL. No comment. No comment, Manley. 1979. Nina, OT, but YSL was wild today. Please don't stop covering it. So I got to be honest, with all these other trials going on and all the other stuff going on with the hurricane, not been able to follow YSL the last couple weeks. So if we get into it, we'll try to. It's just so much happens that I fall behind so quickly in that case. But we'll see. We'll see. All right. That's all we got. I did see the Adelson appeal. I did see the Menendez press conference. If you guys want videos on those, let me know in the comments. Make sure you hit the like button if you have not already. Make sure you're subscribed because it feels like daily recaps for Sarah Boone are today. I may even do one tonight if they do opening statements. If they wait till tomorrow, then tomorrow night will be the first of the trial recaps. But you guys are the best. Thank you so much for joining me. We did this in almost exactly an hour. I love when a plan works out, when it comes together, right? So make sure you guys hit the like button on the way out. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.